Good morning and welcome to today's Ask a Pro Open Mic webinar. Today's webinar is the second installment of our motor vehicle loan series. Thank you to everyone who turned in for part one and welcome to everyone joining us for this session. My name is Milos Gvozdenovic and I'll be the moderator for today's session. For those of you who may not know me, I'm a shareholder for Weltman's Bankruptcy Group and I practice out of the firm's Cleveland office. I've been practicing bankruptcy law for over 15 years and I'm a member of the Cleveland Metropolitan Bar Association and former chair of their Bankruptcy and Commercial Law Section Executive Committee. Let's learn a little bit more about our other panelists. We'll start off first with Garry Masterson.
Good morning, everybody. Garry Masterson. I also practice out of the Cleveland office, primarily handle cases in Ohio, Pennsylvania, New York, and California. I've been with Weltman for over 5 years and practicing over 2 years here.
Thanks, Garry. Our third panelist is Erin McCabe. Go ahead, Erin.
Thank you, everybody. My name again is Erin McCabe, and I'm a bankruptcy attorney with Weltman for the past 10 years. And I handle Eastern and Western Kentucky and Northern and Southern Indiana.
Thanks, Erin. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. The webinar is being recorded. At the conclusion of today's session, a link to the recording will be sent to all attendees. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. I also want to give a quick thanks to everyone that submitted questions during the registration process. Your questions are the foundation of this series, and we're looking forward to sharing our knowledge with you today. Let's get into the first question.
All right, well, I'll start out here. Is it beneficial for a financial institution to mirror the Chapter 13 plan within its core system? What should then occur within the core system if the case is later dismissed, say 3 years later? And are there statutes governing these two related topics? So I'd have to say that, yes, if you have the ability to change your system to reflect the plan terms, that would be ideal. This would basically mean that you would account separately for bankruptcy, pre-petition arrearages, and then post-petition payments. So the problem usually arises when you get post-petition payments coming in from the debtor or the trustee, and you just apply them to your oldest payment due. So they're basically being incorrectly applied, and at some point you look at your system and say, hey, should we file for relief because the debtor's behind, when in fact maybe the payment should have been applied to the actual pre-petition arrearages. So some systems are, have the ability to make those changes, some don't. So we do have clients that actually manually keep a spreadsheet to keep those, payments posted correctly. All right, so the follow-up question, what should then occur when the core system is dismissed 3 years later? Well, again, if the case is dismissed, it's as if it never was filed to begin with. So you really have to look at these payments. Maybe some have been coming in and being applied to arrearages. Some are coming into as post-petition payments, but if the case is dismissed, then you sort of revert back to the original case, which can be a problem if you've already changed it in your system. So, obviously if the case is dismissed, then, if they're still behind, then, you can pursue your state court remedies or repo the vehicle if it happens to be a car. And there are no really statutes related to this other than the bankruptcy code that if, assuming the case is still pending, you're still required to apply these payments properly. Otherwise, you'll probably get an objection. So. All right, question 2. When a debtor files a Chapter 13, they are past due and the plan calls to pay pre-petition. should we bring the account current to the first post-petition payment? If this is the case, should the maturity date also be extended? This is a good question. You could bring the account current, but I certainly wouldn't extend the terms. If you do that, and you may end up showing a balance on your system after the bankruptcy is over with, which could lead to a wrongful repossession or a discharge violation. One way around this is when the debtor files bankruptcy, you could reduce the principal by the amount of the arrearages, so it looks as if it's current on your system, but you won't go over that time period after, say, 60-month plan showing a money still due. Of course, you still have to account for the arrearages, but it can cause a problem if you extend the payment time. All right, question 3, please. All right, we'll switch gears here. Can a vehicle be added to a Chapter 13 after it was previously discharged in a separate case? Yes, of course you can. For instance, if you have a previously discharged 7, maybe they were current at the time the bankruptcy Chapter 7 was discharged, and they can turn around and file immediately and put they fall behind again, they can put those arrears in the 13 plan. One thing to consider too is, the people that are multi-filers, generally, if you're going from a Chapter 7 to a Chapter 13, you can't file for 4 years. Well, let me back up. You can file, but you can't get a discharge for 4 years. So this might be an instance where you're free to file, but you may not get a discharge. But again, filing a 13 after 7 may give a debtor time to catch up if he got post bankruptcy delinquent in the previous bankruptcy. So there are strategies to that why you would file again, but you certainly can always add that into a bankruptcy petition. All right, question 4. What federal or state laws govern the need to mirror the bankruptcy plan within our core system? I think I kind of touched on this in the first question, but there are no federal or state laws that I'm aware of that require you to, change your or mirror the bankruptcy plan in your core system. However, that doesn't mean you're not subject to issues that may come up in the bankruptcy if it's still continuing. So, if you're not applying your payments properly, you may hear about it from the trustee, but there's no law that requires you to do this.
Hey, Erin, we got a question that came in. I think it was based off of question 3, and I think it's a good question just because it's relevant here, and I think it's just kind of resolve any confusion. So the question is, should we not be writing off any remaining balance at the end of the Chapter 13 if there is a balance still due? I think that's a difficult question because that's going to depend on the type of loan that it is. They're really, and Erin, I'll let you field it, but my thought is at the end of the 13, if they complete the 13 as they were supposed to, there really shouldn't be anything left to secured creditors other than their current contractual payments. The only time I would see anything be written off is if there was a cram down or an unsecured loan that gets a less than 100% dividend.
That's true. You could also have some sort of late fee or some sort of fee in that you could even have a repossession fee that was put on there when you had to give the car back that was not included in your proof of claim. So as Milos said, you're going to be paid per your proof of claim, and at the end of the plan, you should be current. So writing the remainder off is more of an accounting issue than it is a bankruptcy issue.
Yeah, I would, my thought is, if the debtor complied with the plan and it was supposed to make you whole or bring you current, and then you have a balance at the end of the 13, that's usually a red flag that there is an issue somewhere along the line, I would say.
Agreed. All right, question 5. If the vehicle loan has cross collateral, is that sufficient to file a claim for other debts, such as credit card, as secured? And generally, I would say yes. You know, for instance, in the Chapter 7, you're going to try to obtain a reaffirmation agreement that has cross collateralization, a provision in there for each debt that's owed to the bank or credit union. In a Chapter 13, you're going to file a secured proof of claim with language saying perhaps it's secured by other asset, or, you know, per your cross collateralization language. You know, the bigger question that I see sometimes is, I mean, 8 times out of 10, I see loans come in with a box with the cross collateralization description being blank. So they don't, you know, a lot of times creditors fail to put that in there. So in other words, if you have a vehicle loan and then 6 months later, a member files for a personal loan, they should put that vehicle listed as a description in the collateral box to show that it's cross collateralized. I think that should be paid attention to more, and often it's not. Having said that, you'll also find some courts that say, you know, you're only cross collateralized up until the amount of equity that's in your car. So if you have a $12,000 car, you owe $6,000 on it with the bank or credit union, that $6,000 is only the amount that's actually cross collateralized as secured. So, you know, that's kind of technical, and you may get objections. In other words, the rest of any other collateral will be treated as unsecured. So I think you have to know your jurisdiction, or for that matter, your judge or trustee, to see if they object to those type of things. So I think the bigger question is, does the language alone in your agreement protect you? And I don't think the question's 100% sure, but I certainly would file as secured and wait for a debtor's counsel or trustee to object.
Okay.
That's all I got here.
All right. Actually, before we get to part 2, we did have a couple questions, and I just wanted to make sure. All right. So, Erin, one of the questions that we had is, hold on 1 second. I'm sorry. If the debt is discharged in Chapter 7, then a Chapter 13 is filed later, does putting the debt in the Chapter 13 reobligate the customer to the discharged debt? If so, does this violate the previous discharge? I would think the short answer to that is no. It wouldn't reobligate them on the discharge.
I agree.
But there was a follow-up question as well. Can a vehicle be added to a Chapter 13 if previously discharged? Previously discharged 13 as surrender, we weren't able to repo. I think a lot of these questions are stemming on the general idea of what happens bankruptcy to bankruptcy. So if I'm understanding the question correctly, if a debtor filed a 13 and they wanted to surrender and the client couldn't get the car, and then they either amended the plan or filed another 13 and decided to include the car, can they do that? Erin, I mean, my thought is yes.
Yeah, sure. I think you could. It's voluntary. It's on their, voluntary.
Yeah, and obviously as a creditor, you can always object. If you feel that they're not going to follow through the plan or the treatment's not acceptable. But anyways,
right.
We're going to.
And maybe I can clarify. Going from a Chapter 7 again, maybe they're current at the end of the Chapter 7. 6 months goes by after the discharge, and now they're delinquent again. They file a 13. Of course, they can include that car and the arrearages, but if that 13 gets dismissed, that initial debt is still discharged, and the only remedy is for the client to go out and pick up the car.
Yeah, the other thing I would add is the reason that someone can include a discharged debt in a 13 is only because it's secured. If it was an unsecured, that wouldn't even be a question. The key here, even though their personal obligation has been eliminated, you as a lender still have a lien on the collateral, whether it be a car or a house. So they still have an opportunity after the 7 and they got their discharge to try to do a 13 to make you whole as a secured creditor, even though the debt itself has been discharged. But very, very good questions. But
So I was just going to add quickly. There is, I don't know if this is in every circuit, but there is case law in at least one circuit I've seen regarding filing a proof of claim for a discharged secured debt. So I would just be careful there. I've had it come up a couple times where the circuit, and I wish I could remember which circuit it was, stated that filing a proof of claim on a secured debt, even though the debtor, of course, like we're talking about, can include in their new 13, is a discharge violation. So in all those instances, I've had debtors' counsels file their own claim so they can make sure it's included in the plan. But just something to keep an eye on. And if you guys need to run it past us, we can always check if that falls, if that's the case in that circuit as well that you're in.
Yeah, I would think that would be a minority view with the courts. I think in most circumstances, even if the debt was discharged and the debtor turns around and files a 13 and you guys have a secured loan, you almost always want to file a proof of claim. I would imagine, what Gary's referencing there is probably a unique situation. Okay, so the next series of questions are going to deal with reaffirmation agreements. First time we had this, we had a lot of questions about this, and I know this has been kind of a hot button thing lately with a lot of our clients. So the first question we have is, can a lender refinance a discharged loan that was not reaffirmed? This is a very tricky question, but I ultimately would say no, unless new value is given for the loan. Even then, I'd have a little bit of concern with that. My concern is that, the problem with refinancing a non-reaffirmed loan is that there's a risk that the court may penalize the lender for using the refinance to circumvent the reaffirmation process. If the debtor otherwise wouldn't be able to reaffirm the loan because their budget was lopsided, or they can't afford it, or the judge disapproved it, I think what it ultimately is going to get to is, what was the reason for the refinance, right? If it's just to kind of bypass federal law to get the borrower back on the hook for a discharged debt, that's going to be a problem. So some of the questions you have to ask yourself that, the court may ask if there's issues down the road: how did you convince the debtor to pay for a discharged loan? Was this an attempt to collect the discharged debt? Why did you refinance the loan instead of reaffirm? Did you try to reobligate the debtor on a debt they otherwise wouldn't be able to reaffirm? What benefit did the debtor receive from the refinance? Was there additional money lent? Terms changed? Why didn't you just adjust the terms within the reaffirmation agreement instead of doing a refinance? So I think it'd be a very rare situation where a refinance of a discharged loan wouldn't raise some red flags. I think the most common scenario that I can see would be a refinancing of a house. Maybe someone wants to refinance for a better rate when rates drop, or they have equity in the house they want to pull out for a project. I can see those circumstances not being an issue. But simply refinancing a loan after a bankruptcy but not changing any of the terms, I think that would be viewed as an attempt to circumvent the bankruptcy code. Okay, so go to the next question. Would a reaffirmation agreement be considered valid if the creditor, debtor, and debtor's attorney all signed the agreement before the discharge date, but the document was not filed until after the discharge order had been entered? The first thing I can say about this is monitor your deadlines. I think that's an overall lesson to be learned on a lot of these things that we go over. Usually the court has deadlines for reaffirmation agreements, proofs of claim, objections to plan. Those are very important. If you miss those, it's usually a big problem. All right, so the question at hand is, so I'm giving a hypothetical example here. The reaffirmation agreement was signed by all parties on January 31st. The following day, the discharge was granted by the court on February 1st, but the reaffirmation agreement was not filed with the court until the day after the discharge, which was February 2nd. So everybody signed it, everybody was on board. Case discharged, reaffirmation was filed, but it was filed late. Okay. Under normal circumstances, a reaffirmation agreement that is signed by all parties and filed with the court, nothing happens. Everyone signs it, it gets filed with the court, and it's a done deal. As soon as it's filed, it's in effect. Normally you're not going to get any kind of court order saying it's approved. You will get a court order for disapproval if the judge sets it for hearing and has an issue with it. But normally, once a document is, the reaffirmation agreement is filed, it's in effect as soon as it's filed, absent some sort of order subsequently invalidating it. That being said, if you ever file a reaffirmation agreement late, even under these circumstances, I would not be comfortable to say that that reaffirmation agreement is enforceable absent some sort of court order indicating it was enforceable. You know, the rule itself actually states a reaffirmation agreement shall be filed no later than 60 days after the first date set for the meeting of creditors. So 60 days from the original meeting of creditors date is the actual deadline, not the discharge deadline. But those are usually the same date. Most courts allow a reaffirmation agreement to be filed after the 60-day mark, but before the discharge is entered. So that's usually not a problem. There is a small amount of courts that if you file a reaffirmation agreement after the 60 days, even if the discharge deadline was not entered or the discharge order was not entered, they still require a leave to allow for the late filed claim. I think if you have those circumstances where the discharge deadline was issued, I don't think the best approach would be to just file the reaffirmation agreement. I think that you or the debtor's attorney should file something with the court, either asking that the discharge deadline be delayed, that the discharge deadline or the discharge order be, I guess, stayed. Sometimes we've had situations.
I just continued, you know.
I think just filing it and assuming it's accepted is probably not the best way to approach it. I probably look into one of three options. Ask the debtor's attorney or request the debtor's attorney to seek for a delay of the discharge deadline if you're getting close and it hasn't been issued yet. Or have debtor's counsel or your counsel seek leave to allow the late filed reaffirmation agreement, or the debtor's counsel can vacate the discharge order for the sole purpose of getting the reaffirmation agreement is filed. No matter which way you choose to remedy the issue, I wouldn't assume that a reaffirmation agreement is valid if it was filed after the discharge date, unless you get some sort of order from the court. So, all right, we got a couple of questions. We do have a question here. It's not on the topic at hand, so we'll circle back on that at the end. We do have some miscellaneous questions. So, all right, can we go to the next question? All right. What are your thoughts on credit reporting on reaffirmed accounts? All right, this is another thing that's come up quite a bit lately. I think you're required to report on a reaffirmed account. I think, you know, the essence of what a reaffirmation agreement is pretty much tells you what you need to do with the credit reporting. A reaffirmation agreement is a document that's filed with the court in which the debtor is personally waiving their discharge on the loan. So the easiest way to look at it is if the debtor signs a reaffirmation agreement and it's filed with the court, that particular loan or debt that the debtor reaffirmed is no longer subject to the discharge. So you would treat that loan from that point forward same as you would any loan that you had, any loan that would be prior to bankruptcy or not part of the bankruptcy. You just treat it like any other loan. There's nothing special about it. The reaffirmation agreement just waives the discharge for that specific debt. So it's business as usual going forward. So I think if they reaffirm the loan, you definitely have to report to the credit agency, because one of the biggest sells to have a debtor reaffirm a loan is to build their credit and have their credit report showing an active account on their credit report. If they reaffirm a loan and you're not providing that service, I think that there's a breach of the agreement or a misrepresentation there, and I think as a lender, you're not complying with the terms of the reaffirmation agreement if you're not reporting it as an active current account. In addition, if you send out a reaffirmation agreement that changes any of the terms to entice the debtor to sign the reaffirmation agreement, whether you take the arrearage and you put it at the end, whether you reduce the interest, reduce the principal, any changes that you make on that reaffirmation agreement, you have to change in your internal system and you have to report to the credit agency. The best way to look at that would be if the reaffirmation agreement changes the terms of the loan, you treat it just like you would a refinancing. Credit reporting would continue, and your internal system should match the reaffirmation agreement if there's any change to the terms. The other couple things with regards to that is, if the debtor doesn't reaffirm and the debt is discharged, it should be reflected as such on the credit report. So it kind of swings both ways. The real world scenario that we see this come up on fairly often is debtor files for bankruptcy, they reaffirm a loan, lender doesn't report it to the credit agency. A few years after their bankruptcy, they go to look to refinance or purchase a house, and then their credit doesn't show any kind of current activity, and their credit report was suffering as a result. They come back to the lender and say, I reaffirmed this loan and you guys weren't reporting on my credit report for 3-4 years. This hurt my credit. That's a valid complaint. But it swings the other way as well. If the debtor does not reaffirm the debt and then you don't show that debt is discharged in his credit report, and then 2 years down the road he goes to refinance a house or purchase a house, and they're showing an account that hasn't been paid for 2 years and is delinquent and charged off when it should have been discharged, they could come back and say, this debt should have been discharged in my bankruptcy, and you're reporting it as an active account in my credit report. That's a problem. So I think those are things that you definitely have to keep in mind, especially in today's day and age, where with the internet and so much information out there. I think people are much more savvy about their credit. It's much easier for people to get their credit scores and credit reports. And I think if you do something that would stemming from the bankruptcy that would be detrimental to their credit report, I think there's a problem there. So, all right, we can go to question number 9. Once a debtor reaffirms a loan, at what stage in the process do we credit report the account as active instead of BK account closed? I would probably say as soon as the document is filed with the court, at that point in time, I would treat that loan as normal. I would start reporting it to the credit agencies as an active account. I would start sending invoices and monthly bills to the debtor on that account. And then, if they fall behind or miss payments, you can contact them directly at that point in time. Because as indicated in the previous question, a reaffirmation agreement takes effect as soon as it's filed. So once it's filed, you're good to go on that one. So can we go to question 10? Can unsecured debt be reaffirmed if the debtor states they want to? Yes. If debtor wants to reaffirm an unsecured loan, they can. All right. Question number 10, please. Or, I'm sorry, 11. If a borrower represented by an attorney calls the creditor, is the creditor allowed to negotiate terms directly with the borrower if the creditor sends the new agreement to the attorney? No. You will have to, if a debtor is represented by an attorney, you have to speak with their attorney directly when it comes to bankruptcy-related matters. If the debtor banks with you as a lender, if it's a simple banking question like, I need to get more checks, or I had an issue with my, checking or savings account, or I have to add somebody to my account, those can be handled by the lender. But anything that's bankruptcy specific, it has to go through the debtor's attorney. The only exception that I could even see is if you got permission from their attorney to discuss something directly. But to me, that's a huge red flag. An attorney should be aware of what's going on with their client's case at all times. If their attorney is kind of just dumping it off on their client to do the legwork, I think that attorney has some issues, and I'd hate to kind of get pulled into that as a lender. All right, can we go to question 12? Can cross-collateralization cover unsecured credit card debt? Yes, as long as it's a valid and enforceable cross-collateralization clause, it can. But be aware, if you're seeking a reaffirmation for a loan and there's other loans or credit cards covered by cross-collateralization clause, I would recommend that you're transparent and you disclose that at the time the reaffirmation agreement is being sent. Chances are they're not going to reaffirm a loan that has an extra $5,000 tied to it. But, I think it'd be disingenuous if you send them a reaffirmation agreement for the car only, and then they pay the car, and then 5 years later you surprise them and say, hey, we had a cross-collateralization clause, you still owe us another $5,000. I think you should put everything on the table. You can also use it as a negotiating tool to convince somebody to reaffirm a loan. It's very common that we say, that we have clients that say, if you reaffirm the car loan, we'll waive the cross-collateralization clause. The benefit to you is you get them on the hook personally for at least part of the loan. The benefit to them is they're not, they're getting a little bit of a, I guess, discount overall. Go to question 13. Actually, we got a question that came in. I'm going to backtrack a little bit. Can a debtor request themselves that we contact them directly, even though they're represented by an attorney? I would say no. You're falling into a trap there. Debtor's attorney should be doing the legwork for them. If they can't get a hold of their attorney, that's the debtor's problem, not the lender's problem. And I know it can be frustrating because there's a lot of attorneys out there that are unresponsive or not doing their work, but don't be tempted to fall into that trap. Okay. Is a separate reaffirmation agreement signed by the debtor required even if our loan is included in their Chapter 13 plan? We usually don't seek reaffirmation agreements in a Chapter 13. If it's a secured loan, it's usually paid in full through the plan or considered a long-term debt not subject to the discharge. So if someone's in a 13 and their debt payments extend beyond the end of the 13, that debt is not discharged. If the payments are within the time frame of the 13, they're usually going to get paid in full. So I think either scenario, you're not typically going to need or want a reaffirmation agreement. Next question. Debtor filed a Chapter 7 and obtained their discharge order. They refused to sign a reaffirmation on a vehicle, but still has the vehicle and is current on payments. What should you watch for? What can be done? At this point, you're at the mercy of the debtor to continue making voluntary payments. You're allowed to take voluntary payments, but you cannot send invoices or call to collect on the debt. And if they default on payments, you retain the right to repossess and sell the vehicle. All right, those are all the questions that I had for the reaffirmation section. So we're going to pass this on to Garry for his section.
Okay, everybody. So we're going to be moving on to our third section here, which is pre-petition vehicle recovery actions and what the effects or consequences are of when a bankruptcy is filed. So a common question, especially in the last year or so, is our first question: does refusal to return a vehicle that was seized pre-petition, so before the bankruptcy was filed, violate Bankruptcy Code Section 362? And then a follow-up question to that is, are sanctions warranted? So at the outset, I will tell you that many of these situations can be very case specific. And so it can depend on multiple factors in a particular bankruptcy case and what has and hasn't happened at this point. So I would always recommend at the beginning that you contact us because in addition to those case-specific facts that can determine what you may do or what path you might want to take, there also can be many time-sensitive issues here where we want to move quickly. So with that out of the way, generally, as long as the vehicle was legally repossessed prior to the bankruptcy being filed, that's not a violation of 362. However, that being said, there are going to be some actions that you generally would need to take fairly quickly in some instances. First, even though your repossession pre-petition is not a violation of the stay, you will need relief from stay, and in a Chapter 7 abandonment in order to sell that vehicle. So while there's not a violation, I would caution that once you receive notice of the bankruptcy filing, do not take active measures on your vehicle. And examples of active measures could be setting a sale date, proceeding with a sale that was set prior to the bankruptcy filing. If that's a situation where you repo the car, you have a sale date, put that sale on hold or cancel. If we can then obtain relief from stay, then you can pick up where you left off, proceed to sale, set a sale, and move on with liquidating your collateral. There are also times where it may be a situation of who moves quicker. So you repossess your vehicle, the debtor files a bankruptcy case, you haven't received notice yet, and the debtor quickly files a motion for turnover in the bankruptcy, or they file an adversary proceeding, and basically they're demanding that the court order you to return the vehicle to the debtor. That I've had that situation come up a few times, and we've had good outcomes in each one. Many times it can depend on the district, it can depend on the judge, and unfortunately with many of these, it can also depend on the specific debtor's attorney. My general recommendation is if they've filed a motion for turnover or the adversary, most likely you're going to want to file a response, unless you have decided you don't want to expend the legal fees and you just want to turn the car back over. If it's a Chapter 13 and a plan has not been filed yet, I always recommend we quickly file a motion for relief, basically trying to beat the debtor to the punch, so that our motion for relief does not look like it's reactionary to anything that the debtor is filing. Many of these situations, the initial bankruptcy filing will be a skeleton filing. So you repo the car, the debtor either had a bankruptcy that was getting ready to be filed, or they quickly run to an attorney, they file bare bones petition, there's no schedules, there's no plan. In that case, we should file a motion for relief ASAP. If a plan has already been filed, I would recommend reviewing the plan first to see what your treatment is. If they're offering to pay you in full, it might be in your best interest to return the vehicle. But still in that situation, it's possible we could obtain a stipulation so that we have triggers and provisions in place in case there's issues in the case in the future. If we have a situation where we filed our motion for relief, I've also had cases where they then file their plan, they complete their petition. Usually what happens in those situations is we can still arrive to a stipulation where we resolve the motion for relief, we accept plan treatment, and if there's future defaults, whether it's direct pay or a trustee pay, you still have some sort of trigger, at least for a limited time, to not have to file a motion for relief again. One thing to remember is you can hold that pre-petition recovered vehicle at least until a plan is filed or until a court demands that you turn over. However, you can't use holding the car as a bargaining chip in order to obtain better plan treatment. So it's important to be careful with that. You can also require that the debtor provide you proof of insurance before you release the vehicle, and that the insurance lists you as loss payee. So onto our sections warranted follow-up question. I haven't had any courts at this point award sanctions following, if we follow the ideas and methodology that I laid out with the previous question. In most cases, with the recent Supreme Court decision in Fulton last year, some debtors' attorneys are not aware of the ruling in that case. So I've found that an initial reaching out to debtor's attorney and letting them know our position and using the Supreme Court case as preliminary backup has usually led to good results. So haven't had a sanctions issue, not saying that couldn't happen, but at the end of the day, it really comes down to what is your goal? And if they start filing a motion for turnover and litigating or an adversary, do you prefer to litigate, possibly expend further legal fees, or can we arrive at a solution that works for both parties without the excess litigation costs? So in short, if this situation happens and you have a vehicle in your possession that was repoed pre-petition, general recommendation to consult with us quickly so that we can protect any of your rights that you may still have in the situation. The next question sort of goes along with this prior question. If we have repossessed a car and the borrower then files bankruptcy, do we always have to give the car back? And what repo fees should be charged? So you don't always have to give the car back. It's going to many times depend on case specific. And in my practice, generally, I advise to not just by default give the car back. As far as fees are concerned, if you've incurred repo fees, storage fees, etc., pre-petition, you should definitely include those in your proof of claim that you file in the Chapter 13. Also helpful to make sure you itemize those, but you're entitled to include those as those were incurred pre-petition. If you're incurring any fees post-petition, such as storage fees at the auction site or the yard, it is perfectly acceptable if you end up releasing the car to try to have those paid. I've had situations where courts have agreed with us that you're entitled to the repo fee and the storage fee being paid before your vehicle is released. There's been other times that we've had all of those worked into a plan. The debtor might file an amended plan to include post-petition fees. So at a minimum, you should include any of the fees incurred pre-petition in your proof of claim. And then our next question. If the vehicle was sold due to a repossession prior to the bankruptcy, would the funds have to revert to the bankruptcy estate? So in this situation, it can depend. If we're speaking of the vehicle was repossessed pre-petition and sold pre-petition, look at what part in the process you are. So did you have excess funds and you've already sent those to the debtor? In that situation, that's on the debtor. That's for the debtor to disclose to the trustee that they have those funds or they may have spent those funds already. If you repossess the vehicle pre-petition and sold, but you still have the excess funds in your possession, my recommendation would be just to cover yourselves, contact the Chapter 13 trustee or the Chapter 7 in that instance, and just confirm with them what they would like you to do with the funds. They may say, send them to the debtor and we'll work it out with the debtor, but you want to make sure to be protected. Another issue that came to mind here is make sure, as I mentioned previously with the 362 violations, that if you obtain that vehicle pre-petition, that once you receive the bankruptcy notice, that you're putting the sale on hold. Because you wouldn't want to run into the situation where you continued with the sale, even though you had bankruptcy notice, you then sold the vehicle, you didn't have relief from stay, you didn't have abandonment, and now you're sending funds to the trustee, and the trustee is saying, okay, that's great, we have excess funds, but why did you just violate the automatic stay and sell the vehicle? So, moral of the story, it never hurts to check with the trustee and always to stay in the trustee's good graces.
Was that your last question?
That was my last questions. I think we have the miscellaneous questions unless we have other questions that came in on that.
All right, we're getting some good questions from the crowd, and on some of them I didn't want to interrupt because they're a little bit off topic on what you guys were talking about, but we're definitely getting them. We're going to circle back on them, but we have a couple of miscellaneous questions that didn't kind of fall in the categories that people were sending in prior to the webinar. So we're going to start with those. I don't know if you guys have a preference. I can start. Okay. Here's some of the miscellaneous questions that came in prior to the webinar I want to touch on. Does a stay terminate after 3 filings within a year, and is it based on the filing date or the dismissal date? Okay. When there are multiple bankruptcy filings, the stay does not terminate. It just never goes into effect. The rule is if the debtor has had 2 or more bankruptcy cases dismissed within a year of the currently filed case, there's no automatic stay in the current case. So if they filed today a new bankruptcy, and within the last year they've had at least 2 or more dismissed, that new bankruptcy does not impose a stay. Couple things to keep in mind. This does not apply if the most recently filed case is Chapter 7. The debtor has to file a motion to reinstate the stay within 30 days of the refiling and demonstrate good faith for the most recently filed case. Usually these get granted unless they're opposed. So if the debtor's filed multiple bankruptcies and they filed a motion to reinstate the stay, you may want to consider filing a response to that. And as a creditor, you're allowed to request an order from the court confirming that there's no stay in place if you need one. Second question, how should we handle a negative checking account that was overdrawn a short time before the date of filing, especially in Chapter 7? I would just treat it as any other general unsecured debt. File a claim if there are assets, and go through your non-dischargeability analysis to see if there's any potential fraud. And the third question that I had, the last one, then you guys can go next here. If a loan is acquired or sold to another bank, does that change perfection date as related to becoming a preference? In other words, does the acquisition bank have 30 days to perfect their lien, or is it 30 days extended? I'm not aware of any tolling to the code section if the loan is acquired by another lender before the lien is perfected. The rule states it has to be perfected 30 days from the date the debtor receives possession of the property. Going back to this overall theme that we said before, make sure you're cognizant of this when you're acquiring loans. Deadlines are very important. If you acquire a loan, see what's been done when, how much time you have to do it. Don't miss your deadlines. If there's any takeaway from this webinar, deadlines that are set by the bankruptcy court or by the bankruptcy code are probably your most important guide in terms of doing things. So, all right. I don't know, Erin, did you want to go next or?
Sure. All right, let's see here. How long do you have to file a proof of claim in a Chapter 13? Yeah, so it's generally, 60 days after the first meeting of the creditors. But more importantly, you'll see on the notice, bankruptcy notice, it also lists the date of the 341 meeting of the creditors. It'll list the specific date where the deadline is. So pay attention to that first initial document that's sent out by the bankruptcy court. All right, is the debtor obligated to maintain insurance on the vehicle after filing? And the answer is yes. They have to, getting back to what Garry said too, another reason to, not turn over the car is if you don't have proof of insurance, of course, on the vehicle. It's a legitimate way to withhold the vehicle until you get that proof, at least in my jurisdictions. If you don't have insurance on a vehicle, you're lacking what they call adequate protection, and it's actually a grounds to file relief from the automatic stay. So in short, yes, they are obligated to provide insurance and provide you with proof of insurance upon request. All right, can we file a UCC to protect our lien filing in the event that the member files before we are perfected on the title? That's a good question. I don't think that will make a difference if I read the question correctly. You have a safe harbor of 30 days for you to get your lien on the title after bankruptcy's filing. So just because a person files a bankruptcy doesn't necessarily mean that your title is not perfected. You still have that 30-day window. Now, if you don't perfect your title, meaning you get your name on the title, occurs maybe, say, 50 days after the filing of the bankruptcy, filing a UCC then or prior to that will not help you. You guys have any comment on that too? Do I read that question right?
I agree. I read it the same way you read it.
Yeah, no issues here.
Okay, so I have 3 questions that I'll weigh in on here now as well. The first one is, at what point can you file a motion for relief when the debtor keeps filing amended plans and very little adequate protection payments are received? So, as I'm sure you hear many times, this can be a question that's more case specific and sometimes would require an individual review. However, at an outset, I would ask, are you entitled to adequate protection payments in your specific situation? Does your vehicle have equity? Is your vehicle depreciating? Is it quickly depreciating? All of those factors and others will go into consideration of, are you even entitled to adequate protection payments? However, if you are entitled to adequate protection and debtor is just not getting their plan confirmed and they keep amending, I would recommend looking at why you're not receiving your adequate protection payments that you're entitled to. Is the debtor not funding the plan? Are they falling behind on their plan payments? Is this a jurisdiction that the court would be willing to grant you relief simply on that basis, on plan payments falling behind? Is there anything else going on with your vehicle? As we've mentioned a few times, do you know it's still insured? That's a measure of adequate protection. So in general, it depends what's going on with your case, but I would definitely review what's going on with the plan payments and if there's anything else in the case that can give you a clue as to why you're in the situation you're in. Next question, how should it be handled if a debtor files a Chapter 7, has a unsecured loan as well as a vehicle loan? The vehicle was voluntarily surrendered and eventually sold. There now is a surplus of funds from the sale of the vehicle. Can those surplus funds be used to offset or cross-collateralize the balance on the unsecured loan? If yes or no, how should the deficiency or surplus letter be written? So at the outset, deficiency in any letters that you send in bankruptcy should be looked at with a fine-tooth comb and make sure they have the sufficient bankruptcy disclaimer language, if you can even send a letter at all. So that's a large compliance issue that I would recommend reviewing those regularly. As far as the main question here, again, if you had a valid cross-collateralization clause or language in your documentation that we feel good about and that it was sufficiently identified what was cross-collateralized, possibly, yes, you could use the surplus funds. However, you're going to run into a couple potential issues that we've discussed in other topics. First, I would want to contact the trustee to make sure that you're not taking funds that the bankruptcy estate is entitled to. And even before that, do you have relief from stay? Because again, if that vehicle is voluntarily surrendered, but the stay is still in place, you can't be selling that vehicle or taking any actions with those proceeds. So your steps in that case, do you have valid cross-collateralization language? Do you have relief? Can you sell at that point? And if you answered yes to all of those, I would still contact the trustee to see, to make sure they don't want to do anything with the funds before you proceed according to any contractual abilities you have. And then the last question I have, can we file a proof of claim in a Chapter 7 for a vehicle? So normally, no, at least not as secured. The majority of Chapter 7 cases are no asset cases. However, if the Chapter 7 were to become an asset case, you or your attorney would receive a notice of assets, and there would be a proof of claim deadline that would be set in that case. If the case has become an asset and you have a deficiency balance, so you legally sold the vehicle pre-bankruptcy or during the Chapter 7, you obtained relief and sold, you can then file a proof of claim for the deficiency balance at that point, and I would attach the deficiency letter to your claim. Or if you have relief, but you haven't yet sold the vehicle, you can keep your foot in the door by filing an estimated deficiency balance in that sort of situation. So summary, as secured, no, but your deficiency balance, yes, you're free to file.
Okay, thanks, Gary. We have a few minutes to circle back on some questions that have been asked prior. There was one relating to my topic on reaffirmation agreements, and it's a real good question. Can a reaffirmation agreement be requested verbally, or does it have to be included in petition? If you have any indication that the debtor is going to sign a reaffirmation agreement, whether they send you a letter, call you, whether it's on the statement of intention, go with it. The statement of intention is not binding. You know, we've had situations where a debtor says they're going to surrender collateral and they change their mind and they reaffirm, and then vice versa, they want to reaffirm and then they don't. And then there's a question that kind of pops up here that I thought was a really, really good question that had a lot of appeal to anybody that's handling bankrupt debtors. Let's see here. Hold on one second. Got a lot of questions. I'm sifting through it. All right. So the question is, what is considered notice of bankruptcy? When the debtor tells the lender verbally, or when the documents are received from the courts? Okay, so I think notice is notice. You can have actual notice, constructive notice. It's when you first get notice, right? Whether you do a scrub of your files, whether you get a letter, whether the debtor calls you to let you know. Once you get notice, you get notice. But the reason I think this is a good question is, you know, even though you may not get the notice for a month or two, or even sometimes you don't even get the notice at all, you know, always be cognizant that as soon as someone files a bankruptcy, the stay is in place automatically. So the way that's been interpreted is, even if you don't have notice, once that document is filed, that debtor is protected from the bankruptcy court. So the question then comes up, and well, you know, we didn't get notice, and then how does that work? And if we did all this stuff, you're going to have to unwind it. But I think if you don't get notice, it doesn't forgive you for what you did, in the sense that you don't have to undo what was done. But I think it forgives you in the sense that you're not going to get penalized if you violated the stay if you didn't have actual notice. So I don't know if Gary, if you had something to add?
I would just add, this is a great reason and a great question of why I would strongly encourage electronic noticing, because especially now with situations in the past with mail and still ongoing, mail takes a while to get, sometimes it gets lost. I would really encourage signing up for electronic noticing, and that way, if once the court issues any sort of notice, you're not going to only get it quicker, you're going to ensure that you receive that notice and minimize the chances that you have to undo anything or explain yourself.
Okay. Just to let everybody know, we're going to try to get through as many of these questions as we can. We may bleed a little bit past noon. If anybody wants to stick around past noon, we'll go a few minutes past. But if anybody wants to drop out, you can always go back and view this webinar through our archive. So let me just kind of go through these questions. That one was kind of like a comment. Let's see. Hold on one second. Sorry, I'm sifting through these questions here. There's quite a bit. Okay, if a member files Chapter 7 on a share secured debt, is the funds that are held for this debt considered the credit union's to offset the loss of the discharged debt? If I'm reading that question correctly, this is a loan that was secured by member shares or money on deposit. So then what happens with that money? I don't want to monopolize the answers here. I don't know if anybody wants to kind of jump in. But I mean, my experience
is about like a secured loan backing a loan of some sort.
Yeah, I think the question is asking you if the loan is secured by money on deposit, whether it's a CD, member shares, in the case discharges, can they essentially offset or repossess those shares? My thought has always been, as long as they have a valid security agreement, I'd say yes. Okay.
Would you think that they would need relief from stay on that?
Yes. Okay. Correct. Subject to relief from stay. But if the case is discharged and the trustee abandoned his interest, then I think you're well within your rights to offset those funds if they're not paying on that loan.
I agree.
Agree.
All right, this is more of a comment than a question. I'm gonna have to skip that one. I'm sorry. Let's see. Here's a question. This actually came up recently with another client, and I'd like to get Erin and Garry's input. I think this will be our last question because it seems to be a little involved. So, all right, if the credit union's policy is to deny credit or services to those who cause a loss, when should that be disclosed to the debtor's attorney? Up front after notice of bankruptcy is received, or only if a plan is confirmed, which will result in the loss to the credit union? I think that's a great closing question. I don't know if you guys had any thoughts on this. I kind of thought it through because I had this with another client, but if you want me to go ahead, Garry.
I mean, I think in general, I can't say I really had this come up, but as far as communicating to debtor's attorney, I mean, the thing to keep in mind is if you have a confirmed plan, there's not a guarantee that case is going to be successful, and not that doesn't cause you the loss, but you're going to revert to be able to pursue your debtor for any obligations they have to you if it's dismissed. So I think part of the strategy there is, do you stand to lose any more if you communicate something like that to debtor's counsel too soon? So it could be a maneuvering game, but Milos, if you've had that situation, I'll let you take over.
I mean, I have to kind of agree with you, Garry. It's kind of a delicate balance, right? Like, is the credit union, what's the word I'm looking for? Are they within their banking rights to do that? If they are, at what point in time does them exercising that right violate a stay or a discharge order? I think ultimately the answer is, if they were legally allowed to do that before bankruptcy, I don't see a reason why they can't revoke someone's privileges after bankruptcy is completed. But the question is, at what point in time? I've always been of the thought that if they do it before the case discharges or the Chapter 13 is completed, I think it's being done a little prematurely because you're not 100% sure at that point in time. I don't think anything has been finalized in terms of whether they officially suffered a loss.
Right.
But we did, but we did have a credit union raise a good point and say, well, if a plan confirms at 1%, we're gonna suffer a loss, and I tend to be more conservative. I say, well, they didn't get the discharge yet, so you can conceivably still get the money from them if the plan fails. I think as long as the case is open and active, I'd probably wait until everything's completely done before taking that action.
I agree, because until that discharge order is entered, you're not being paid out on that 1%. You're still, if they dismiss, you can pursue completely. So I agree. I don't think you've actually suffered a loss until discharge.
Yeah. So, all right. If there's nothing else, I'm going to make some closing remarks and thank everybody for attending today's webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 30 webinars that you and your team can view on demand. Our collection offers information on a variety of topics, including consumer collections, probate recovery, and real estate default, to name a few. We'll send you a link to the library in our follow-up email. Thank you again for attending, and have a great rest of your day.
Thank you, everyone.
Thank you.